So we're starting our roundtable discussion on the contract law issues. I can introduce my colleagues. Artyom Karapetov, LLD. I'm sure you're familiar with his works. He writes a lot. He's a prolific writer. He teaches a lot, including the Russian School for Private Law. And I'm pleased to introduce Andrei Yegorov, who's also a graduate of the Russian School of Private Law, and he also teaches there, and also working in the High Arbitrary Court. So I'll start with Artyom Georgievich. Can you hear me? Dear colleagues, my speech is dedicated to the freedom of the of agreement and contract. I will cover I will make some general remarks about the freedom of contract in the context of contemporary European contractual law, and tell you what happens in the Russian law, in the Russian legal environment, and cover the novels of the Civil Code that refer to the freedom of contract, connected with this draft law being passed by the Duma. After studying some foreign sources, I came to the conclusion that both both courts and legislations of European countries use two main principles. First of all, the autonomy of will of two parties that derives from the general principle of private law, that everything is permitted if it's not prohibited. But after certain considerations of the 18th century, in the 20th century, we've come to the conclusion that it's not a sacred cow principle, but it's a presumptive principle. Many countries agree to the principle of the freedom of contract, but it can be constrained by the existing legal system. And there are certain grounds for that. In summa, freedom of contract is a basic principle, and it's part of the draft of the draft of the law for reference, but it contradicts certain considerations of moral philosophy, of fairness principle, that has to do with contract law, with the corrective fairness and distributive fairness. American and European experts have been discussing this issue over the past 50 years, and there are a lot of works written on the subject. But there might be different considerations in favor of restraining freedom of contract, but there's a presumption in force. Those who propose those constraints are liable for them. Sometimes in discussions we come across a situation when you speak in favor of some non-standard clause to be included into a contract, they start telling you that you have to prove it's not dangerous. Otherwise, we consider it prohibited, or I think we should presume contract free, and the presumption of freedom of contract has always been in the basis of the Russian contractual law. Over the past 30 years, the consumer law has developed, bringing those experts in civil law. They rather put the burden of explanation on those who advocate the freedom of contract. That means that dispositive norms and all norms of contract law are dispositive, especially those that refer to labor contracts and other types of contracts. But dispositive requirements become imperative. And the more we turn away from these dispositive norms, we cannot. Well, the High Arbitration Court is starting to use this approach. If you look at the of the information letters number 146 and 147, you can see what kind of approach the High Arbitration Court is implementing. So we are working on the base. Our basic principles are that can restrain the freedom of contract freedom, are requirements of defense of moral values. Since the parties always fight for their own interests, they are not taking into consideration the rights of the parties that are not included into the contract. All economists and all lawyers adhere to that. Sometimes we have to stop or terminate various deals and contracts, limit the competitive issues, and another claim is to make contracts fair. Economists think that defending a weaker party always costs something, and this cost always becomes a burden for the weaker party, and this kind of defense has no result in nothing. It does not happen often, always. Foreign lawyers have been struggling to solve this problem over the past years on the subject of reissuing costs, the paternalist costs on one of the parties. When we're talking about labor contracts, for example, we're still far from understanding all those links between the legal institutions, including restraining freedom of contract, and the way these changes influence the deals and agreements being signed. However, all legal systems use the principle of defending fairness of contract, making it an equal principle. Some even say we should abolish freedom of contract in favor of equality of contract. But still, we're still treating these two ideas as equal. When we're talking about defending fairness of contract, we have to remember that legal systems, both British and American and European system, that strive to review contracts taking into consideration fairness and equality, only happens in two cases. First of all, when we have a weaker side, or when we have inequality of battering power. And European courts, or German court, keeps using this criterion, trying to understand when a party can be considered a weaker one, and when can it accept or gain support from the government or from the state. Well, the High Arbitration Court has already started to speak about the weaker side, the weaker party in contract, because it allows us to think when we can talk about the fairness of contract. So the first example is defense of the weaker party. We can at least explain why we should defend it, and here we have our moral principles implicated. No matter how much it costs, I mean, we're not talking about the costs, we're just helping the weaker side, involving, thus we're referring not only to contractual law, but also to consumer law, defending clients, or labor laws, defending clients from unfair competition, controlling fairness of standard contracts. The second basis for intervention when ensuring fairness of the contract is not on when the weaker party is not defended professionally enough. In European law, we sometimes come across situations when the weaker party cannot be when the weaker party defense rule also is applied to individual contracts between individuals, not legal entities, because individuals are not always competent enough to make a rational choice. And the third reason for intervention is a situation when we're talking about business people, when there is no weaker party, but the contract is strikingly unfair, which tells us which shows us that the negotiation went in an unequal environment, and we're talking about abnormal contracts, which tell us that there must have been some problem within the negotiation process, and thus creating an abnormal contract. These principles, these three principles serve as a basis for intervention in defense of the fairness of the contract. What we strive to do is to ensure the defense for the weaker party, and European law is way ahead of us. If we compare this law we have to the consumer law in Europe, you can see that they have very long blacklists of clauses, or gray lists of clauses that cannot and should not be included into the contracts. On the other hand, the fairly liberal regime is applied to the contracts between businesses, or B2B contracts. While the freedom of contracts, those B2B contracts, can be reduced only in view of the state interests, or if we're talking about fairness, it can be reduced only when we have proved the inequality of contract possibilities. For example, when we have a monopolist company or some commercial company that is a weaker party in the contract. If we're talking about larger deals between businesses, intervention is very rare. Intervention cases are very rare. If somebody is selling real estate for 3 kopecks, foreign courts often think there has been some breach of will. Trying to build the balanced system is possible if we're using certain tools. There are 2 main tools abroad. input control with imperative norms when the legislator says, well, this is not accepted or this is not allowed. And these imperative norms. The second instrument is post control, when people include general provisions into the contract, and the judge later uses the civil code provisions and limits the freedom of contract. Here the judge is liable. And we should not underestimate those imperative norms, because they are sometimes excessive, and this norm is very hard to focus on the needed constraint. But sometimes they're not enough, because they're not fixing the problems or fixing the issues that should be fixed in time. And courts make mistakes, and legal systems try to play both games. When the reason for constraint or restraint is obvious, they use it. Especially, there are a lot of imperative norms in the European legislation, in many codes, in German code, referring to consumer contracts. They have a separate chapter. In labor law, they have this imperative from the very beginning. Competition law also uses this imperative. And so in general provisions, especially in sales agreements, service agreements, there are no imperatives of this kind. Everybody knows that you shouldn't make an agreement about eliminating certain types of liability. So there are certain restrictions and constraints, but the rest of the regulation is dispositive. And the norms that are registered in the contracts, they are often used to refer to the court, to refer those courts to the norms.
And then it is written that this is a norm that is imperative, it is an indefinite status norm, and this is the majority in French law, and there are a lot of norms in the unidentified norms. Then the court has to give an explanation. Some countries went as far as to give the presumption of the dispositive norms in the law in their civil code, if it proceeds from the essential conditions. So there are two main approaches in Estonia, for instance, and in Ukraine. And there's also the Dutch code. Each chapter starts with the explanation that all of these norms are dispositive except for several others. But the French and German approach is more widespread, and the code does not prescribe the type of the norm, but the courts presume that this is the type of the norm unless it is considered to be otherwise from the actual contract. So this flexible approach is part of the main frame of reference of the European legislation. This leads to the situation when most of the norms in Europe are dispositive, and if there is no other explanation. So there are few dispositive norms, but the courts are exercising post-control. This is a very important trend in the European legislation in the last third of the 20th century. The German court block the unfair conditions and protect those who give loans, those who sign the contracts. And in the Dutch legislation there was Article 248, which stipulated that any unfair conditions may not apply in court. 36th paragraph in the Scandinavian law, an unfair or dishonest condition will not be applied. Now, this was the first code. The Americans in the 50s in the trade code had paragraph 2.302, and the court does not apply unfair conditions. And then the Dutch raised to the same level. And the court has extra functions of additional control. The unconscionability condition works very well in the US law. And there should be two criteria present, the procedural unconscionability and conditional unconscionability. And the court first has to understand whether or not there was unconscionability. If it did take place, then the court looks at the content. If there is some unfairness, clear unfairness, then the court may put some restrictions on the contract. And these two criteria work as two vessels that have a common level, and the lesser the unfairness, the higher is the threshold of fairness. And a lot of American courts say that if the unfairness level is very high, then we can ignore some of the procedural factors and intervene into the contract just based on the unfairness of conditions. The analysis of German law shows that, and practice shows that the German High Court applies the same criteria using the same principle. What do we have in Russia? Unfortunately, in Russia, this is a system where the contracts are fine-tuned. In some places, there's very little liberalization of the broader understanding of contracts is not quite applied, not to the full extent. So it is very difficult to transplant the same norm. We have to protect the consumer, but in some cases we understand that the consumer does not need to be protected. When our tycoons are buying yachts, then sometimes they don't need our protection. In any case, in our country, the system is not quite exact. We have a lot of imperative norms because the main idea is that all the norms are imperative unless otherwise indicated. So this presumption cannot be overturned, even though in the text it follows that there's no way you can be treated as imperative. The courts automatically take it as an imperative norm. Russia is the only country in the world of that kind where such approach is still valid, and this leads to the fact that a lot of imperative norms are not reasonably applied just because no restriction was written in the law. And the only thing you can do is to put if in the text, and it was decided to skip it. So in some cases it's a technical aspect, and we have to try to depart from this. But because we have so many imperative norms in our legislation, contracting under Russian legislation becomes a walk on a minefield. One step aside and you will get blown up. Article 287 in the Civil Code does not make it possible for the services market to develop in a normal way, because each of the sides may cancel the agreement without explaining the reasons. And at the same time, there's a very unfair distribution of the consequences, because if the contractor cancels the agreement, then he will have to pay the amount of work done. However, if the other party cancels the agreement, then they will have to pay off all the damages. And the amount of compensations from the cancellation of the agreement and the term, the duration, the period during which the warning should be sent. So all this is very unfair. Until recently, the post-control by courts did not work very well. Over the past few years, the Supreme Court started applying Article 10 of the Civil Code to block anomalies in contracts. Until very recently, this did not work very well, and I think this became a basis for the legitimization of the super imperativeness of our legislation. So the courts are not able to monitor the contracts because they don't have a mechanism in place, so they try to control the situation at the entrance level, at the input level. I believe we have to change this balance of powers. We have to strengthen the control and accept the consequences, some of the consequences that will follow. But we have to decrease the level of imperativeness of the norms in our civil code. If you look at the reform of the civil code, I have to say that there are positive and negative aspects. The positive aspect relates, if we took it in a narrow way, we have to see that the freedom of contract is strengthened, and a lot of norms become dispositive. If you look at the number of dispositive norms in the draft legislation, in the contract law, you will see that their number increased. At the same time, a lot of contract structures are regulated, and the courts before did not apply them because they believe that if it's not clearly written, then it does not exist. And a lot of lawyers did not want to structure such deals under the Russian legislation because there was no guarantee that such deals would be deemed viable. Escrow, option agreement, a number of other novel types of agreements, the ones that Anton Alexandrovich mentioned earlier, with a critical view. There are a lot of new instruments that have appeared. I believe they developed in order to ensure the honesty of some of the agreements. This may not often work because the company may not have enough assets, but in order to argue this, I say that you don't have to write everything. Not all obligations need to be prescribed in contracts, especially if there is no assets and the conditions may not be implemented. But this is a different matter entirely. This can be written in different thing. It does not belong to the contract law. On the other hand, the legalization that we talked about may create some problems. And every new instrument creates additional problems because every tool, every instrument can be used both ways. Insurance can be used in order to avoid taxes. Any kind of a new type of agreement can be used unfairly. We just should not be afraid of that because we understand that we have to have a certain set of tools, set of instruments. Our Supreme Court and our Court of Arbitration are competent enough to be able to stop dishonesty. We should not be afraid of the new because someone may use it unfairly or to their own ends. In any case, in this part, we have quite a lot of positive developments that help to regulate contract relations, even though sometimes, under Russian specifics, they may be used to different ends. In terms of negative consequences, I would mention here the proposal that that was mentioned several times, the qualification of imperative norms in Russian legislation. There were several proposals of that kind, two, in fact. One, if there is an indefinite status norm concerns the regulation of concluded agreements, then its nature should be determined by the court by interpreting its ends, its goals. And the second step is to accept the presumption of the dispositiveness of the norms not only in case when this can be said clearly in the contract, but also when the nature of it can be derived from the text. We have to make the first step at least to ensure the imperativeness which cannot be changed. And the higher court of arbitration has been making the first step very carefully. We have examples in the court practice when they called several norms dispositive wherever they found if. But I cannot say that this is something that is quite obvious. This is a trend. I think we need to make this first step. We need to make sure that we have to understand that our courts are competent enough. And if the status of the norms is undefined, that we have to move towards dispositive norms. The second step has several very important arguments against it, and one of the arguments says that possibly we had to do that in 1994, but the regulation is based on the imperative presumption. And yes, in the second part of the Civil Code, there are a number of norms where certain conditions are missing. There are several norms where this if phrase was not added in order to make this norm imperative. Now, if we change the presumption, then some of the norms that are considered to be imperative will be questioned. So a proposal was voiced that we should reform the second part of the Civil Code. We will mark all those norms that need to be disposed, and they have to be marked as such, and then we can change the presumption. I would say that this argument is strong enough to not to make the second step for a while, but I think that the first step should be definitely, and I mean here the right of the court to interpret the norms with indefinite status, undefined status as imperative. I believe that we will have to make this step in the future. And the final thing is that we cannot possibly mark all the norms. When the Germans prepared their civil code, they had this idea. They wanted to textually mark every norm as dispositive or prescriptive. The countries that tried to do that usually tried to mark imperative norms only, but it is very hard to do. It can only be done only if you have a very strong doctrine, a very wide and broad judicial practice. Usually, the norms are transplanted or borrowed from other countries, and in many cases, nobody discusses whether or not a specific paragraph is imperative or prescriptive, and whether or not this certain ruling, certain decision is fair enough so that it could be used as a presumption. It's very hard to say until you actually look at the specific case. If you look at foreign law, we'll see that there are millions of different types of imperative, half-imperative norms, etc. There are super-imperative. We don't usually use this term. However, there are half-imperative norms that can be interpreted both ways. They can be applied to contracts with commercial partners, but not with consumers. Sometimes they can be interpreted one way to worsen the conditions and sometimes to better the conditions. And it is impossible to mark all the nuances in the text of the legislation. But I agree that some of the clearly imperative norms that have not been textually marked today in the second part of the Civil Code should be somehow marked and possibly inventorized and named. And then we can move on to the second step. And I would like to finish my presentation. Thank you very much.
I think we will have a more general picture later, and some of the issues will simply move away. At first I planned to talk on a different matter. I was going to talk about the principles of for share and for loan relations, and we're still discussing, and we have doubts whether we did the right thing when drafting that law. But if we have time later, we would be able to talk about it. But now I would like to share my views on the problem that Artyom Georgievich has mentioned. I personally don't like this attitude, this approach in the courts. I call it, positivism in its worst form when the judge looks for all answers in the norm and he feels binded by norms. I rather prefer the German approach, which was covered by Artyom Georgievich, and not only Germany but other legal systems in Europe, at least, they follow the same kind of rules, the same set of rules. So the idea is that the law does not formulate whether the norm is imperative or prescriptory, or it's non-mandatory or facultative norm. However, in the comments for older contract law, they make it clear whether the norm is imperative or dispositive. I think we'll have to go the same way, and there's no other way we could take. We don't have 100 years ahead to do it, but in 10 years I do hope we could make this journey. If we are active in the field, we could be able to reach the goal. I do not think we'll be able to initially, when we're creating a norm, to define whether it is dispositive or imperative. No legislator would be able to predict everything. In the end, it's court practice that will decide. And I would like to give a number of examples from the High Arbitration Court to show you another side of the problem. It proves that we should not boil it down to imperative or dispositive character of the norm. Not everything is okay if the norm is dispositive. In the end, eventually, it's the court practice that in litigation we find out it can be only one-way dispositive. It's something Artyom Georgievich said. It can be dispositive for a consumer, and there'll be false expectations, because someone might think, well, this norm is dispositive, I can do whatever I want, but in the end, they'll tell him, no, you can't. So I don't think that legislators should define whether a norm is dispositive or imperative. I think it is something that should be done in courts in the process of litigation. If we accept, or if we vote for the civil code, and if it is accepted by the High Court, I think that in the preliminary notes, I think we should give an idea to the courts that they should interpret the norms using legislation in a broad sense. I think we have to find two good examples where a norm is framed as an imperative, but it can be also used in other ways. I think we have to persuade the judges that are going to vote for this code to take this into consideration. While we're trying to look through all the norms defining which ones are imperative and which ones are dispositive, it's completely impossible. We'll keep to this legal positivism. If the court names this norm an imperative one, or legislator, once we get to using this norm in litigation, well, if the contract can give different provisions, then it should, and that will mean that most unfair contracts will come to life. I don't think we should teach the judges to reject their positivism. They have to be taught a doctrine which has this understanding, and Artyom Georgievich is working hard to make it happen. I think that could be a practical and the most effective way to solve this problem. Now to the examples. Speaking about the norms that are initially phrased as dispositive or non-mandatory. I think we had information letter on the 319th article of the Civil Code. What does it say? The norms say that if the sum that comes to the party is not enough, then they first, well, the debt is calculated first using the percentage and later using the whole sum of the debt. And the courts acted differently. Some of the courts said that this norm is dispositive. That means that the parties may agree. Of course, it's the banks that strived for these conditions. They decided that this forfeit would come first, and then they will pay the rest of their debt. Other courts said, well, these stages should not include forfeit. The head of the arbitration court, he chose the second one, that the forfeit should not be included into the payments. But at present, what we have a dispositive norm, which has its own limit, and its limit is defined by the higher, by the court of the higher jurisdiction. It could happen in an actual case. We have to live through a certain number of years and see how these norms will be interpreted in actual litigation. A second plenary decision on loans. It has a comment. A comment is included. It's in the 39th amendment. It says there was this clause on loan in the loan law. When the loan holder brings a product or an object to an auction, the initial price is set at the level of 80% of the market price, as if in case the parties had not agreed on something else beforehand. Well, they could have agreed that the initial selling price could be 1% of a selling price. Why would the legislators need this 80% at all? The plenary session of the arbitration court said it was a dispositive norm, which said that you can make this price higher, that is 81%, but you cannot lower this percentage. Well, it brings us to a philosophical question. The paternalistic nature of the state is at work here. There you have this jar with spiders, and let's see who survives in the end. Those who survive will live in good faith until a new spider comes to the new jar. And that's what it boils down to. And the third example, which is still not reflected upon by the higher courts, but here the legislator initially tried to make a norm dispositive, but his attempt was inaccurate. I'm talking about the civil code. That is not that part of the civil code that is not to be altered under the current reform. It's a norm number 975, which refers to it's about a commission agreement that the commissioner, if you ask me to do business for you, if I have to buy something, theoretically, if I have to buy something for you, I can ask you for an advance. payment. For example, I have to pay 1 million, and I don't have it at hand, so I ask you for 1 million. And in this case, this positive nature of this norm is acceptable. It's not a problem if I have a spare 1 million. We're not talking about 10 rubles. But in a case when I have already spent the money, can we agree that on the fact that can we sign a commission agreement that does not provide with anything, that does not reimburse my costs, my expenditures? I've read a very interesting work written by Mr. Antimonov on the types of liabilities, where he writes that in a commission agreement, it's important that the commissioner is acting for someone else. And if this commissioner sees that the expenditures he paid for the party that commissioned him, he's stepping out of this commission agreement. And I think we have a thesis that in the commission agreement is acting for another party, and if his expenditures are not reimbursed, how can he be party of the contract? I think that this type in the Civil Code of 1922, it was not even mentioned, and the commissioners had to provide for the execution of the contract. Normally, the courts would not refer to whether the norm is dispositive or imperative in this case, but there's this mine laid here, and when interpreting this norm, we have to link it to the commission agreement that one of the parties is acting using other parties' money, other parties' funding. On the whole, there's very little I can say. I mean, I can only agree to what Artyom has said in general, but I don't think this thrust should be in changing the law, altering the law. But I still understand that to a large extent, many judges, especially elder judges who were educated in a different country, they still have this tendency to keep to imperative character of legislation.
Can you hear me well? Well, first of all, I would like to support what the previous speakers said, Andrei and Artyom. In fact, I would like to just emphasize some things in terms of the assessment of our professional attitude to the law and legislation. It is obvious to me that we all, as a professional community, should strive to change the mentality. And when my colleague said that the courts and court practices work, and I should say that we should not concentrate on courts alone. And in many cases, there are settlements outside courts before the trial, and there's latent criminality, and why don't we talk about latent violations of the law? I can see some representatives of the notary public, and I'm sure that our colleagues could tell us a lot about what people come to the notary public in order to have stamped and signed, what kind of deals they have. And we often understand that the judges see the living law, And I think, of course, the profession of a judge is at the very top of the pyramid. But the judge does not borrow from above, from outside, from beyond the clouds, the knowledge of what is going on, of the law. So we should not just understand, but to feel. And this is important both for the legal professionals who have experience. It is important for students, for professors of law schools. Law is a living body. It is made every day. And the argument in court, when one of the parties shows the civil code, show me where this is written, it's awful. And this shows our unprofessionalism. If we had everything written in the law, we would not be needed by anyone. Because people who can read Russian, they could just open up the book and find a solution. The law is a living body. It is influenced by many different factors. It is influenced by the economic situation. And as the economic situation changes, we change our perception of how the risks can be distributed. The political situation changes, and it changes our understanding of how the norms can be interpreted. Social factors influence the situation as well. The audience here is more or less, as far as I understand, is interested in the practice of the commercial courts. But we also have the common jurisdiction courts. We have a lot of people, citizens, who come with their disputes to court. And let me tell you, they all act in following the principles of the civil law. Several billions and several dozens of rubles for citizens and for companies may be the same thing. In terms of the specific weight, they are one and the same amount of money. So if you look at the courts of common jurisdiction, you would agree what I say. A lot of courts are governed by the feeling of pity. And that's how they interpret the norms. Can we hope that the judge would never take pity on someone? No, we can't do that. So when we take this piece, or this part of the ruling that is published as a comment from the Supreme Court, we can say, well, what is it that they're doing? How is it that they interpret the norm this way? But we don't know what kind of person was standing right in front of the judge, and who and what did the judge protect by ruling this or that way. And I'm not saying that this is the correct way to do it, but we know that it exists. And it's good when we talk about this, when we lecture our students. But if we were judges, if we had live people in front of us, I think we should admit, all of us, that poverty has its own rules. It dictates other interpretations. And a lot of our citizens are poor. It sounds very beautiful when we make proposals for amendments in the civil code, especially when these amendments are proposed by people who speak foreign languages, who are very smart, who are aware of the court practice. They represent big lawyers' firms. But let me ask you, these proposals on the provisional provisions, dispositive provisions, how would millions of our citizens view these proposals? And there are millions of our citizens who try to be entrepreneurs, who try to feed their children, try to live decently. It's the same code for all of us. The same logic applies. We should not discard this. And in order to find the right solution, in order to find the right approach, also in terms of the formulating the text, I should tell you this is a very hard job. How do you write the text in such a way that millions of people understood it in the same way? Well, I shouldn't say in the same way because it is impossible, but the way it was meant to be. And before that, you have to decide what to write. So this cannot be not taken into consideration. We should take it into consideration. But first we need to change the attitude, our attitude, the attitude of professionals towards the law. I believe this is, if not, this is even a more important thing. And as a professor, I believe it is much more important. It is important so that our legislation worked in such a way that it strengthened trust. There's something that I wanted to say to you, and I can't help saying it. There is a research in the area of European contracts, collateral law and taking collaterals for giving out loans, and the EBRD published the results of their research and various polls. By the way, there's another drawback of our legal profession, that we do not usually use polls or research in order to base our assumptions on. And this information is available, it's just usually ignored by the representatives of our profession. We say this is a hypothesis, this is a dispositive provision, blah, 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 and it sounds very well. We all like symmetry. From the times of the law of Byzantium, we like the symmetry, we enjoy it. But the EBRD, the European Bank of Reconstruction and Development, published the results of their research. The security that can be trusted most, what do you think it is? Well, I'm not going to tease you. The trust to the counteragent. That's the best security there is. That's what entrepreneurs believe. So the established relations, the trust that was developed towards their counteragent is the best security of all. The civil law should work to improve the trust between the participants of the market. That's the main goal of the civil law. And now a few words about the content, about what we were talking here about. I started on security transactions, and let me give you some transactions as an example. I have two examples for you, although of course we could find more. Let me illustrate one of the problems that I believe should be resolved by us as soon as possible, both from the point of finding the language for the legislation, but also in terms of understanding how various provisions can be applied. When we talk about applying norms, when we talk about enforcement, we're actually talking about everyone who reads the provisions, who tries to apply the provision in their professional activities. The European legislation, both the legislature and those who enforce these provisions have a problem, face a problem. How can you bring together the formal and functional application of provisions? The formal is quite easy. You look at the norm, you try to analyze in a formal way. But every provision has some reasoning behind it. It was formulated because it serves some function. So one can interpret the law in a functional way. That is, the main emphasis is made on what this provision was made for. And if we're talking about the contract law, then what specific provisions were included in the contract for? And the results would be very different. Let me give you the first example. Artyom Georgievich mentioned this, the securitized right to property, and I think you all understand what we talk about. Now, if we look at the conditions on which a certain property can be taken as a security, if we approach this problem formally, then we should not use this institution at all, because the right to property is the full right that covers the entire object, and it should be a formal right for the owner. And for a long time, this formal approach meant that the right to property could not be cancelled. But if you look at the functional interpretation, if you look at the means for which this provision was made, the end interpretation would be very different. And the answer is provided in the document that I mentioned earlier, the draft common frame of reference. It is used in European private law. There are 10 books in this document, and book number 9 is dedicated to proprietary law. And this book, the majority of this book, is dedicated to the in-rem security based on its function. And I believe it is a very interesting publication. I think it is a very secure type of regulation. The second example is this. Imagine a situation. You have a borrower, you have someone who gives a loan, and it doesn't matter what kind of loan it is. There's one more person who enters the transaction from the side of the borrower, who is ready to pay off the debt on some basis of solidarity, but this person is used as a collateral. He is a co-signer. From the formal point of view, we have a normal obligation with several persons as one party. But this co-signer, if you assess the situation in a functional way, and both parties have agreed on the function of the co-signer when they enter the agreement, if we look at it in the functional way, then we'll have a different structure altogether. So from the formal point of view, you have 2 borrowers, but you have one classic borrower and the other one is a co-signer. And the relation with the creditor and other co-signers, in case this other co-signer would have to pay something, they would be based on other principles, on the principles of that serve this particular function. So this is a formal and a functional approaches for you. I believe I can't say that we should always use the functional approach, but if you look at the market, if you look at the transactions, you will see that this functional approach should not be ignored. It is impossible to ignore it in the current situation. On the other hand, we should understand that law is a specific system of provisions. It's an element of the overall culture. It is a formalized culture. So when people say that lawyers prefer formalized, all things formalized, then in fact they are being paid a compliment. Well, you can't go away from formal and formalized things. In any case, I believe that today we should not over-exaggerate this approach, and we should not concentrate it as a single approach. Things change very rapidly. And also, in civil law, we often have to catch up. Between the 19th and 20th century, we tried to catch up with the German law. Now we're trying to catch up with the so-called developed countries. We cannot ignore these approaches. We have to try to line up with what's being used abroad. And this is one of the most interesting problems, both for the researchers in the civil law as well as for practitioners, especially if we try to take into account the modern conditions of the market.
Thank you. We've listened to 3 highly interesting speeches. And although we have been united by the same topic, but they're very different, if I give a general description, what I heard, it's about the norm, the court, and the principle. These are 3 approaches to law. Let us probably ask questions and make short comments. Questions to the speakers. Maybe comments directed at the audience, but I would only ask you to introduce yourself. Vsevolod Baibak, Chair of Civil Law of the St. Petersburg State University. I would like to make a couple of comments on what has been said. You've been speaking about the difference or how difficult it is to provide for this positive or imperative character of norms in the law. I will give you an example referring to the Naval Trade Code and trade insurance. It does not imply whether the norm, the provisions it gives, whether they are dispositive or imperative. It was done in 1929 for the first time. As for what Andrei Vladimirovich has said about the necessity of handling it over to the courts, I always take it very cautiously, because in the early 20th century, the sacred book, Pokrovsky, in his book about civil law, wrote a whole chapter describing how important and how valuable law is, a law being integrated and being wholesome. If you're writing laws for us, make them solid. So if we pass over the control over the essence of the legal environment to the courts, I think it's dangerous, because we can see it in the High Arbitration Court when the hearings, the High Arbitration Court not only interprets the law, but it creates new norms, new legal norms. Sometimes these norms are quite fair and are formulated in good faith, like in Article 53 of the Civil Code that says that the parties are not liable to return everything they had before the contract was concluded. So the arbitration court and the decision of the arbitration court that made them handing back the extra revenues they had. Another example is an information letter in which the arbitration court said that the offsets, the money that is to be paid in a case of breaching the contract, or credits that are to be paid, should not set off payments, should be made before the contract is concluded. And I don't think we should entrust the courts or the judges with interpretation of legal norms. And another example, implementing Article number 24 of the Civil Code. I've dealt with the history of the implication and implementation of this practice, and I found out that it had been interpreted in several different ways several times. That means that the court is still not ready to perform the role it is assigned to. Because, I mean, sometimes, I mean, they're not partners for legislators, or they should not act as gurus. I don't think we should pass over all the liabilities and to the court when they produce dubious verdicts and biased verdicts as well, and it might prove dangerous even. If when talking about arbitration courts, we have a certain perception. We see how they interpret the law, what approaches they have towards the law, and they take high credit for that. However, the level of trust towards the courts is much lower. But like civil courts, for example, they are of the same nature. They might want to use this right to interpret the law. I think it would be optimal to provide for the dispositive or mandatory and non-mandatory nature of norms in the law. A law is not a manual. It cannot describe everything, and many issues should be discussed and decided by courts. But as amendments to law, they should follow the legislator and not run in front of him. I'm fine. Can I just react to the comment? Because I find it very interesting. Vsevolod Vladimirovich will probably tell me of a country which has actually implemented those beautiful ideas proposed by Iosif Pokrovsky in his early 20th century book. If you tell me where it is, I'm ready to set off, because the critics was aimed at the courts. Well, Iosif Pokrovsky disliked many types of deals and agreements, and I remember it very well. I mean, can you tell me of the country that has this beautiful system? About set of payments and reversible power of set of payments. I could not find it in this, anything referring to it in the civil code. It exists in a doctrine. As long as we don't have something in the civil code, does it mean that it doesn't exist in the law itself? Or it was overlooked, or it was implied that the set of payment is irrevocable? I doubt it. I would like to mention Reinhard Zimmermann, who publishes his works and proves the following. We in Europe, all of us, live with the revocable power of set of payments, and this is not right, because 600 years ago, when working with the Roman law, when accepting Roman law, we took something wrong. We misunderstood something in the Roman law. So if, in the end, if we're entering a one-sided transaction, in the Middle Ages, they probably, wild as they were, in the Middle Ages, they did not have. They did not allow for these payments to be irrevocable. But nowadays, it's one of the few norms that is part of the changes introduced into the civil code. We made an analysis in the draft common law frame. We tried to find which countries have this element. They have it everywhere. We're going to reject this norm. Where is the expertise? Why do we reject this norm? If we take it, I didn't want to criticize the code, but I have very different opinions, and I do not agree to the fact that this norm should be excluded from the code. Professor Bogdanov, chair of civil law, Academy of Ministry of Justice. We'll have perfect laws only when we solve our theoretical problems. But as it is impossible, we're not likely to get perfect laws. We'll have to improve it, and I think that kind of modernization we have now, it's not a final stage, but only an initial stage. And in the future, this modernization process will take on forever. There's contractual law, speaking about contractual law, I would like to speak about the ownership right or proprietary right. Sometimes I don't think we should overlook certain issues that refer to the ownership right. For example, some shipment agreement, supplier or the other party, well, the supplier, they ship their cargo using this agreement, and the ownership right passes over to the party that receives the cargo. What happens in the process? Who owns the cargo when it is being shipped? But it's a sacred cow. We are not refusing it, and we have to probably, in some cases, use a more complex architecture of the ownership right. Sometimes now, for example, speaking of the liabilities, the liability structure is also different. It's also becoming different. The liabilities without guilt, we cannot readdress the right, but at the same time, we cannot explain it using the traditional approach to the ownership right. Some other examples that have to do with the ownership right in contract relationships. Everybody knows that according to the 454th article of the Civil Code, it regulates change of the owner, but it also describes a possibility to sell off your property rights. And these rights can be sold and bought according to the norms of buying and selling objects. I think a colleague of mine who has been working with the 24th article, what is it? A cession, a sales agreement, when their property rights or ownership rights are being bought and sold. In the project for changes in the Civil Code, there's a certain article that according to the debt agreement, loan agreement, sorry, the party that provides a loan, there's only one clause in this agreement that covers all kinds of property rights and ownership rights, and also objects that are passed over to the indebtor, and according to this loan agreement will pass the ownership right to the indebtor. So what do we conclude? What do? We either treat it as a complex architecture of ownership right, or we introduce a separate group of agreements that pass over ownership rights. We're not talking about property. It will be, we're not talking about property itself, only about the property rights. In the 807 article of the Civil Code, we have a separate clause on passing over securities or we have to make a certain clause that we're not talking about loans, we're talking about a different type of relationship.
I'd like to comment the two previous comments. I think it's a very interesting question. It's a very interesting issue. And there will be a lot of problems of that kind. They will we will face them all the time, but we'll have to say, do we want to listen to Professor Pokrovsky, who advocates the principle of fairness and believes that the court should not interpret the norms and all the norms should be prescriptive, or should we listen more to the European practice? And this European practice shows that there is an overall trend to deformalize the private law, and this is something that we cannot avoid. When Professor says that the future is for the formalized law, a few years after the publication of this book, the Germans, whose civil code he criticized, started destroying the formalized law under the Article 138. The German authors who worked on the civil code would have turned in their graves. The time changed. The time changed so quickly that it was impossible to support the reform of the civil code through legislative reforms. Every decade, the law changes even more quickly. The internet has appeared. The conditions of life changed. However, the process of legislature is becoming more and more expensive in a democratic society. In the past, the emperor had to sign the law to make it a law, but today we have a huge machine. I'm talking about the developed countries, of course. It's a huge structure. And even when we developed the civil code in our country, we had discussions that were carried out for several years, and we had to compromise and we had to agree on stuff. So there are different sides to this. It's a very complicated and a very expensive process. Trying to find compromises is very difficult, and that's the first reason. The second reason is that the creation of general principles can be discussed in the State Duma, the principle of fairness, etc. It can be discussed in the parliament in any country, but you cannot discuss the details of in-rem law in the parliament. It does not make sense, and that is true about a lot of different specialized areas of law. The parliament, the members of the parliament, are not competent enough to discuss such matters. This is another reason why the courts are delegated this function. And third is that it's very hard to find the right answer. In the developed countries, the practice develops very quickly. There are books and books, volumes and volumes of comments. We have researched formally, but if whenever you open a book, you don't find any answers. If there are any questions, if there are any points to be taken, for example, Mr. Novak and Mr. Gerbudov, they wrote books. Well, there are two different conclusions that you can make: is formalized law and the contrary law. Well, the lack of doctrine doesn't make it possible to create good norms, because if you don't have a discussion, you don't see the advantages and disadvantages of every way you take. So if you don't have the doctrine, and in some places you have a doctrine and still they find it difficult to find the right solution. Let me explain how this works in Europe. The courts have the function on finding the fine distinctions. They appeal the decisions, they appeal to the higher courts, and then the higher courts decide whether or not these distinctions are true. And when these distinctions are approved, then they become an imperative norm. So this is a conversion law. So at the level of imperative norms, which are known to everyone, we can see that those restrictions are selected that have gone through the practical application. And I think you were wrong when you said that practice is wrong. Here in this country, where we develop so quickly, it's a good thing. Well, but you said common jurisdiction courts. That's a difficult issue, and I have my own opinion on this. I think we should not look at the courts of common jurisdiction. We should take into account their rulings, their decisions, but we should not take them too much into account. If you look at the types of settlements and type of disputes that are heard there, we can say this. These are mostly the disputes between the citizens who have disputes on housing and on consumer rights. So citizens versus citizens, or citizens versus service providers or those who sell products. And of course, in these spheres, we should take into account the decisions taken by the courts of common jurisdiction. But if we're talking about collaterals, if we're talking about contracts, we should not pay too much attention to the decisions of such courts, because if we do that, we will not be able to follow the dynamic. Obviously, you have to look at the weakest link, but in some cases, we have to look at the golden middle ground. May I clarify something? Well, let us give the mic to the floor. Please, I have one comment to make. Well, you have to understand that we are not talking about contract law any longer. We're talking about the most actual problems that we face here today. I think I will be departing even further. I can't but say that what I heard about Professor Pokrovsky is all wrong. The ideology of his works, his own principles, were determined by the fact that he was a citizen of his country and a lawyer who tried to use the instruments provided by the civil law in order to make the person protected. He wrote about the future of the civil law when he talked about the regulation of several areas of law. What he wrote on non-property areas, he thought that he had to describe it that way, because, as I said, the law is a living body. It always has to be taken within the context of its time. So please, please, please don't say anything like that about Professor Pokrovsky. And I know that we have a lot of young lawyers in the audience. Please take a book by Professor Pokrovsky. Read an introduction to the books by Professor Pokrovsky. So, anyone willing to ask questions? Dmitry Gilet from Pромsvязь Bank. I yesterday participated in a roundtable discussion on the presentation of legal systems, and the representatives of the continental law, France and Germany, mentioned some of the advantages of their systems, and they thought that one of the advantages was the fact that everything is codified, so everything is clear. So you read the code and you apply the code. I heard different ideas about the principle of disposition of the dispositive norms, and even though the norm may be dispositive, it may not be dispositive in the eyes of the Supreme Court. So I have a practical question. I'm not talking about entrepreneurs, I'm talking about business, I'm talking about legal entities. What criteria, what principles should we be guided by when we define the relations between counterparties? To take into account the fact that on the one hand, all of our norms are imperative by default, and on the other hand, even though the norm is a dispositive norm, a dispositive provision, then the business faces a risk that the courts, using inexplicable criteria, in many cases they may be different, depending on specific people, may rule differently. So how do we build our business in this situation? How can we develop our business if we cannot predict, cannot predict our future? Are there any simple and clear-cut criteria that could be clear for the business, that the business could use in order to determine the freedom of the contract in every possible case? I will try to say something else at the end, but we have 10 more minutes that we can spend on questions and answers. My name is Dmitry. I represent the Academy of the Ministry of Justice, the Department of Civil Law. A colleague of mine said something about the predictability of law. It's a very interesting question. I also enjoyed Artyom's presentation on fairness, and Natalia said something very important about the honesty and predictability and the trust that should exist between the parties whenever they enter into contractual relations. And that's the same thing that we can say about the predictability for the business. Be fair, be honest, and then the decision of the court will be easier to predict. The interesting thing about the current situation is that I totally agree with Dmitry on the fairness, and Andrei Vladimirovich said that the principle of fairness and honesty was adopted. We saw a letter from the ministry when one of the articles was blocked, and the court, based on the bona fide condition, changed the conditions in the contract because the entrepreneur was forced certain provisions upon. Because he was the weaker party, he only joined the contract. So in my view, the entrepreneurs should be honest when they enter contractual relations. We have to be fair, and we should interpret it as as following the accepted norms in the society. And the court is the higher instance that interprets this. So we interpret the law not by dividing the law and morality, but we bring them together. And a few words about Professor Pokrovsky. Obviously, I don't want to say anything bad about the distinguished researcher. Professor Pokrovsky warns that there is a danger of having one judge being Christian and the other supporting the principles of Nietzsche. And so for the Nietzschean court, the Christian morality would be considered to be the ethics of slaves. He would uphold the other principles, so there is a risk of arbitrariness of judges, but it is a calculated risk, because if we give the function of if we give the courts the opportunity to judge the contracts based on the principles of fairness and honesty, we will be able to build a new modern system.
I forgot to say, I mean, do read the new version of the 428 article in the Civil Code. It's a new article. The article it is not working about collateral agreement or amended agreement. It becomes an instrument to provide for the contracts with a weaker party. If we're not talking about standard provisions, but it has a weaker party which has been denied a right to influence the contract, but now the weaker party can appeal and will have an analog for like of an American contract law, and that will enable a high arbitration court, and it has already used this tool. There's a problem now that they're trying to make a requirement for standard type of contract inevitable, but this in the adhesion contracts, this tool will be used, especially in the arbitration courts, and that will be very good. But you should understand that in the current, contemporary world, there's no choice. We either do not develop civil law at all. So what shall we wait for? Do we think that legislators will become different and start to make perfect laws, to write perfect laws, or will allow the courts, using your business examples, to work out these norms? the audience is eager to listen to you. So in fact, there's such a huge scope of problems. And it's not a scope, it's not a circle, not that we're talking about many problems, but we're getting to the gist of law, not only contractual law. Let's forget about, we forgot about dispositive or imperative norms. Let us answer a question, a final question, and derive from it. And try to solve, it's difficult to solve, but at least to define our attitude towards minor issues. What do we expect from law? What do we expect from the norms and regulations? If we don't have any other interests at play in certain cases, but in general we want fairness. There's nothing else. That's it. That's what we want from law. That's what we expect from law. And here we get to the most difficult part, because fairness in its absolute form expressed in law, it does not exist. Fairness is also always something transitional. Well, it does exist in certain things. Look at what we used to think was fair 20 years ago, and what do we find fair today and unfair today? Yuri Kirillovich has showed you everything about privatization. I was for it. And I was a fool, I admit it. What do we do with it today when it's not working, and when those the owners of apartments have to perform capital repairs? Can a law, as such, provide a norm with a fair rule that will act for a long time, that will be enforced for a long time? Vindication objects from the buyers who buy them in good faith. And we find this norm to be fair. In our law, even the way it is registered in our provisions, in our norms, it hasn't changed. But in other cases, it's all very vague. We had a lot of examples. Who can make corrections? Who can make amendments? With all due love towards Mr. Pokrovsky and my deepest respect to his works, but he wanted the same thing. Let's see what kind of law or court he was writing about. In his times, it was less complex, it was less complicated. It had a smaller scope of problems. The rhythm of life was very different. The Tsarist court of Russia was very different. It was far from ideal. If we go down to the first level of jurisdiction, it was far from being ideal. And this was the position. He wanted fairness and predictability. Can the law provide clearness, certainty? It looks as if it can. But what do we do with the situation when we understand that the law is outdated, that our ideas of fairness have changed? There are many cases when we cannot alter the law very quickly because the doctrine doesn't have a clear picture. The only way out is a court, certain policy, certain court policy, litigation policy. It's far from ideal as well. How many, with the speed we have to work with, when the cases are brought to the courts of appeal, and well, in the best scenario, only the high arbitration court only starts to act in a year in a year and a half after the case has been started. Well, people who sign contracts, they want to know what happens, what they should do. We still in this. We're still trying to solve these problems. We have to minimize the negative outcomes of bad laws, of bad court practice. Our moral values and the basis of our behavior. A lot of what is happening now happens not only because the laws are bad or the courts are bad, but because the society is different. We keep referring to foreign examples, or, well, if we take classical countries that seem to be very close to us, like Germany, speaking about civil law, it's a different society we're talking about. Well, there are exceptions, but an entrepreneur, a well-known entrepreneur, will never act the way our entrepreneurs act. I don't feel good saying this about my compatriots, but we're still lagging behind as a society, and new problems will emerge. Speaking about imperative and dispositive norms, I think that today we're having the best way we can choose is the level of our court system. This is something we should raise with all possible means, because eventually it will impose those moral criteria that we could use as a society on the whole. We're talking about the common jurisdiction courts, about the arbitration courts, but I can see young people listening to us here. Well, look through the rulings of the arbitration court that date back to 15 years ago. Have a look and see how well thought out they were, how well formulated they were. This is the normal way this is the normal path we should follow. A good law, fast correction in the court, informing society about it, and we'll do it based on certain legal principles. Well, I'll give a few words about imperative and dispositive norms. We, being experts and professionals, legal professionals, especially those who work with commercial law, we tend to forget people behind these norms. When we're talking about larger companies and corporate law, they are far away from common people, and it's not very important what it boils down to. I mean, what will be the end? But if we're talking about small and middle-sized businesses, if we're talking about single proprietors, sole proprietors, we're talking about people. We have to remember that we're talking about individuals who are behind these cases, and this is what the law is for. And even when it's used to resolve disputes between oligarchs, eventually it should work for the society and for real people. What do we do with dispositiveness and imperativeness? I do disagree with Artyom Georgievich. I think there are two sides of a problem, and we have to consider them both. And they're so different that the solutions should be different. Well, the first issue is that of the limits of this positiveness. As a general principle of contractual law, or liability law, we should be careful with that notion. It's a principle of dispositive nature. But if today we take the number of limits and constraints that have already been imposed on these norms, I don't know if we have anything left of this dispositive nature. And when it starts to be implemented on the level of entrepreneurs, we do lack this dispositive nature. What about the limits? We know that there's this consumer law. We're trying to argue whether it's public or private. But then we say relationships between entrepreneurs, agreements and bargains between entrepreneurs. But we're not talking about the same people. We're not talking about homogeneous groups. Large companies will simply kill smaller businesses. Remember the trade law we had a few years ago. Large retailers, they simply killed small suppliers. And we have to understand that when we're talking about limits, about it's not enough to use only these two groups, entrepreneurs and consumers. We need to be more distinctive. Maybe we should distinguish between farmers and other types of entrepreneurs. So far, we don't have any real tools to distinguish between huge corporations like Russian Aluminium or a gas station. But we have to distinguish. Otherwise, we'll keep saying that this dispute can only be resolved through court. Either rule that the agreement has been abnormal or void. But when the parties will negotiate in an equal position, they are unequally represented in the process. And you understand that when on one side, I'm not naming any legal firms, even in a very good court, if you're defended by specialists and non-specialists, you're not equal in your right. Whom are these norms made for? And then we have the second side, which is very complex. And here I agree with both speakers that we cannot have an absolute solution for every norm. But you did refer to the Dutch code. But the Dutch code is very different from that in Russia. See how many clauses they have about buying and selling. Their code is initially aimed at court. It leaves a lot for the court to decide. And they have, for example, 2 imperative and 8 non-mandatory articles. But here, when we have that amount of regulation we do, we have to work with different kinds of entrepreneurs, with a different type of society. And often you cannot predict or you cannot define a norm as an imperative or a dispositive norm. Speaking about tools, there used to be an article on trying to create a law on laws. Nobody ever tried to develop this these tools for the civil codes, and maybe it's not the place to do it. But I think we'll have to provide the norms for the norms. How do we express, how do we understand these norms? I think we'll have to work out the set of tools. Otherwise, we won't be able to say whether the norm is, and for the norms that we cannot define as imperative or dispositive, we have to find, in these cases, we have to find some presumption. We keep speaking about this from the judging the level of obligatoriness, of mandatory nature. I think we have huge spheres of relations when we're not talking about defending consumer interests, but the turnover has become standard. It cannot exist in a different way. Well, when you're taking flights, when you're buying energy or telecommunications, the nature of relations make these norms imperative. We cannot allow for dispositiveness. Otherwise, we'll only be defending interests of large companies. Large companies, well, Article number 428 will probably work well in this environment. But I think that we had a very free discussion here, and we did not talk that much of contractual law, not as much as we should have. But we managed to come across the issues which are important for this country.